Good morning and welcome to the regular meeting of the Town of Bethlehem Industrial Development Agency. It is 8:02 a.m. on Wednesday, April 26th. My name is Victoria Storrs. I'm the chair of the organization. I'm going to go around the room and ask the members to state their names to confirm we have a quorum, and then I will introduce the staff and other guests.
David Cadera, board member. Victor Franco, board member.
Ted DeBarbieri, board member.
Richard Cutlow, board member.
Okay. With 5 members present, I confirm we have a quorum. Also joining us via remote this morning is our executive director and counsel, Kate Hedgeman, our CFO, Al Michaels, and here in the room we also have John Taylor, our senior economic developer. Do we have any other speaking guests this morning or staff? Okay. Our first order of business, we just accomplished the call to order and quorum determination. Our next order of business is approval of the minutes from our March 22nd, 2023 regular meeting. Do we have any questions or comments about the March minutes? Okay. I will entertain a motion to adopt the minutes.
So
Thank you, Dave. Is there a second?
Second.
Thank you. All in favor of approving the minutes?
Aye.
Any abstaining or opposed? Okay, thank you. The third order of business is the report of the senior economic developer, and I will note you're on here twice, John, but you can do it just once.
Thank you, I appreciate that. So just a quick update. Couple things just on the planning side, just things to be aware of. I think I've mentioned this before, but the town zoning update is underway. Again, that's to implement changes coming out of the comp plan that was adopted last summer. So that process will be going on, for the rest of the year, but we'll be having our first public meeting at the end of May. So again, that process is ongoing.
The town zoning.
Zoning, yes. Will be updated. Yeah.
Consistent with the comp plan.
Correct. Yeah. So, particularly, there are a lot of issues, but particularly around, housing and some of the changes that were called for in the comp plan. So yeah. So that's going on. Similarly, the Delaware Avenue Complete Streets project is also moving forward in the design phase right now. We will be looking to have a public meeting for that in mid-June, but the town has hired CHA Engineering to assist with that project. So a couple of projects going on the planning side. We should be hearing any day. The Albany County has put together a plan for its ARPA funds with about I think there's $30 million total that they'll be releasing, $8 million of which is earmarked for really for economic development, and it's a pretty wide range of kind of subcategories within that. So I'm still waiting for the applications to come out, which is when we'll have the detail, but obviously we'll be looking at that for our businesses and for economic development issues in town. The last thing, I just wanted to give a brief kind of update. As you know, I attended the IPF Offshore Wind Conference just about a month ago now. Really interesting conference. I mean, so this is really the as it says in its name, it's the international. So it was really a global audience. Every major company was there in this industry. I think it was the 10th year that they've done this conference. My first time, but it was interesting hearing how they just said it's very noticeable how much it has grown, even over just the last couple of years, and how much this industry is taking off. Just a couple of, I think, kind of interesting takeaways, from my point of view, and for us as we think about it, right? I think, right. So the types of companies that were there, tier 1 suppliers, tier 2, tier 3 suppliers. So the tier 1 suppliers are the companies that make the blades, the turbines, the towers, the foundations, right? All of those major components that go into it. And then you have the tier 2 and tier 3 suppliers that make all the pieces that go into making those tier 1 components, the bolts and different steel pieces and cement and flanges, all these different pieces, right? So so it was really interesting, even just getting to walk the floor, talk with different companies, particularly on the tier 2 and tier 3 side. I think one thing that was interesting and thinking about from New York's perspective, and this came up over and over again in the conference, is how much of some of the decision points for tier 2 and tier 3 companies are really dependent on what happens with the latest NYSERDA solicitation. So basically, NYSERDA is the one kind of leading this charge that they put out a bid, I guess it was last year, it came due early this year, but for companies to bid on the next round of leases that would be made off the coast of Long Island, right? So those are all of the major wind developers that submit, and once those winning bids are announced, and I think it's going to be later this spring, then everything will kind of come into motion of, all right, where are new tier 1 manufacturing facilities being built, and then those companies start to fill out their supply chains for tier 2 and tier 3. So all that to say is, like, it's kind of an interesting time to have the conference. We're kind of in this waiting game to have that announcement made by NYSERDA, and then things will kind of we may have some opportunities to engage more with those other suppliers. So so that was kind of one big takeaway, just kind of where we are in timing of things. The other thing I thought was interesting too, just as we think about, because I think one thing we've heard is, because a lot of these companies have been active in Europe for a long time, right? That they've been doing this for decades, and the concern is that maybe they could just ship over supply components from their existing manufacturing base in Europe, right? Well, there's also still a ton of demand in Europe, and there's new projects going up all the time. So the idea that as a long-term strategy that they could do that and also meet their demand in Europe and their demand in the U.S. isn't really practical. So this supply chain is coming, and it in fits and starts and different points, but it is coming, and we certainly have an opportunity here. So I'm happy to talk more as you have questions, but it was really interesting and a good opportunity to engage with our county and regional partners who are really active in this space. So that's all I got.
Thank you, John. Item number 4 on our agenda are reports of committees. The Finance Committee met last week. Dick, would you like to give us an update about what the committee discussed?
Sure, we met on last Thursday. It was a good meeting. We discussed the first quarter, looked at our revenues and went into our expenses, and really the big expense for the balance of the year is the grant to the town, and we had a discussion on the status of that and how we proceed, and we're waiting to see what the requests are, and I think we had a report on that last quarter. We spent time on our investment policy. We reviewed our current policy, and the main thing about the policy is we discussed really the approved banks. And there's a list in the policy of the approved banks, and we just went through them and discussed to see if there's anything we should include or omit. We had a little bit of a mix-up because we didn't have our current location, but David and I, we knew who was included, and we discussed that. And for those of our policy really is insured banks. That's what we can invest in. We also went over the procedure we have for collateralization deposits, and we reviewed briefly our report, which we get contemporaneous, and we have market coverage on 102% of our excess. Actually, it's 102% of our deposits are collateralized through M&T through an outside source. So our collateral is fine and is more than sufficient in that market. So we went through that. We discussed the fund balance review policy and basically decided to keep it the same as it has been. And you know, Al and I are going to look at maybe laddering our CDs so that we have some in different maturities and perhaps move another $250,000 in. So we have sufficient liquidity and we're invested. Our investment income is really going to be for us significant for 2023. So we're watching that. I think those are the key elements of what we discussed. Anything else? Victoria, anything else?
The insurance?
Oh, yes, good, thank you. And it really comes out of our current legal situation. Kate has been reviewing our insurance coverage, and currently we're named insured on the town's policy, and we're going to go out and seek proposals to have our liability insurance, just so that we make sure that we have coverage and we're independent and see where that goes. And we hopefully it'll be within the realms of our affordability, and we'll look for our own insurance.
Yeah.
Kate, is that right?
Yes, and I have a few calls out to get some quotes. The other thing I just wanted to mention to you and Al and the rest of the board, I spoke with Joe Scott yesterday, and he gave me an update on the Plug Power closing, and the value of that project has gone up, I believe, to $85 million. And therefore, there's a $850,000 IDA fee. And as you know, we have our profit or our sharing agreement, fee sharing agreement with the county. So roughly our income would be $212.50. That's pretty hefty, $212,000.
This year?
$500. So I just wanted to mention that because it's higher than we thought.
That's excellent. Thank you. Oh,
And I think that's going to come in this quarter.
great. That's wonderful.
Yeah.
I don't need this. There's the only other thing, and is further on the agenda, is we did discuss a engagement letter with Kate for the port location, and we'll frame that and get through that later in the agenda. But that was also a takeaway item from the finance committee. And it was just last week, so our dues aren't complete. But you know, I think I covered the key points of it was a pretty good meeting. Yeah. Anything else on that?
I'm looking at Ted.
The one thing I looked, we talked about credit unions as possible inclusion. New York Conference of Mayors has supported legislation to allow credit unions to take deposits from municipalities, municipal entities, or boards like ours. But that legislation hasn't moved yet. So something I looked at subsequent to the committee meeting, but nothing for us to discuss other than information.
I think they've been trying to get the deposits for
a while.
Yeah.
It sounds like
since Noah.
Right. Since Noah. Okay. I don't know if it was that far back.
Okay.
Yeah, at least it moved through the Senate last year. It didn't move through the Assembly. So we're studying it.
Okay. Thank you. Back to you, Madam Chair.
All right, thank you. Under new business, the first order of business is the approval, the discussion, and then I'll ask for approval of a retainer agreement with the Hedgeman Law Firm specific to the Article 78 that has been filed against, me in my capacity as chair. And so I will turn the next couple of items over first to Kate and then to Al.
Well, I think with this, Dick had made the suggestion, and I agreed that it is outside the regular scope of the current retainer with the organization. And also, there's an indemnification agreement between the port and the Bethlehem IDA with regard to the transaction. So if something like this should happen, they do have to pay your counsel fees. I have already tendered the letter to them regarding paying attorney's fees and that I would be representing the IDA for that. So this agreement is to cover the court litigation. Right now, it's very light. There's a stay in place of this particular action because the other actions that were previously filed have the same issues and are still pending with a motion to dismiss. So I don't anticipate too much work on this right now until the other, um, litigations are resolved. But I would be billing the court directly for that and recouping from them. But you are the client, so it's important that I have an engagement letter.
Kate?
Yes.
Listen, I think you should bill the IDA for your services, not the court, and the court in turn request reimbursement for, this is a little different than a transaction. You represent us on litigation, I think,
I can't do that. I'm not Tom, so I'm not an employee.
No.
I
Bill it
can't.
to your law firm. Why can't we have an engagement letter with you? Okay, the engagement letter runs between your firm and the IDA. I think, okay, that's just my suggestion, that you bill the IDA and the IDA in turn looks to the court to make us whole, because it's litigation, and I don't think there should be some confusion between who your client is.
There is no confusion of who the client is. And what my concern is my own ethical obligations not to split counsel fees with non-lawyers. And there's been in this area some issues even with in-house counsel in this with regard to municipalities. So technically the IDA is the client, but because I'm an outside law firm, you really can't be asking for reimbursement of fees. Like I have to direct bill those.
I mean, it is subject to the indemnification. So if the third party says, well, why was she getting paid by the court? We have something to show if that's your primary concern.
Okay, I'm just speaking.
That doesn't bother me, at least
Okay.
just because because we're voting right now on a representation agreement with the Hedgeman law firm for us.
Right.
We say it's our call what she has say with respect to legal strategy, but it's our decision whether or not to settle or do whatever. We're the client, and we have something to show with respect to the payments.
Okay, I throw it on the table. I'm not. It's fine with me.
What I am going to do, Dick, per your request, is put in there that I'll make my best effort to recover fees, and bill the port first. I'll copy, everybody on that and what's being done. I don't anticipate any problem whatsoever. I've already talked to them about it. But I just don't want necessarily the IDA trying to recover, fees when I can direct bill it. So I just don't want to step across an ethical line by sharing fees this way.
Yeah, I don't know.
That's all.
That brings up another point, Kate. And maybe it's me. I feel that if the port doesn't pay you, we owe you the money. Now, how does that work? But I mean, you're
Agreed, right? But
I understand the question, and I'll let Kate speak in a moment. we have a very solid indemnification agreement with the port. We have an excellent relationship with the port. They are receiving financial benefits from the IDA. If they chose to go against their written and some verbal reassurances that we have had, if they choose to upend those, I would be shocked.
And just so you know too, when we close deals, if I have time in on a pilot or something else that was a transaction, that all gets paid to me directly at closing. I don't bill the IDA for that either. And that's customary in the industry that, Joe Scott doesn't, bill the IDA and then you pay him. It happens at closing or it happens pursuant to indemnification agreement, like in this case. Yeah, but I see what you're saying. I mean, I suppose if they did not pay, you would have a cause of action against them on the indemnification and therefore would sue them for that. But that's what would happen. Yeah.
Okay, but my point is that's not your problem. Okay? It's not pay when paid. That's my point. My point was we owe you the money.
Yeah.
Regardless of whether, how wonderful of a relationship we have with the port. I've been in business where all of a sudden you have a great relationship until the check has to be written. Okay, I am just trying to anticipate an issue that may or may not exist. And if nobody else thinks it's important, that's fine with me.
Are there any other questions or discussions for Kate?
Ted, do you, I don't know whether I'm articulating it properly, but, I mean, do you see what my issue is with like the port getting reimbursement?
Yes.
Yeah, it's just,
Yeah, no, and if they don't pay, and we need to send a letter telling them that we're going to sue them because they haven't paid, you're going to get involved anyways through your role as so we will keep, she's going to be involved at each subsequent step should what you're imagining happens or what you're contemplating could happen.
You can imagine.
I'm totally comfortable with that, and I love having a representation agreement, a retainer agreement for this litigation, and I'm in favor of it, and I'm excited about the way you framed it.
I just had a question about the scope of representation. So, to represent the Bethlehem IDA, but because the chair was referenced as kind of like a separate, referenced separately within the Article 78, does that also need to be reflected in the scope of representation?
No, because it's in her official capacity. And just so you know, that is not the proper way to sue an IDA. So that the caption is wrong. And, sometimes lawyers do that for a certain effect, but it's in her official capacity. And as in her official capacity, the IDA indemnification agreement of their officers and board members kicks in. So she doesn't have a separate interest here, I think is what you're asking.
Okay, so yeah, as long as the chair is captured underneath the scope, then I'm fine.
Thank you, Victor.
Where we go one, we go all.
Right.
I guess I just have a couple of questions. Since, the last 48 hours is the first time I actually saw this. And so, I haven't been out of the country for 2 weeks. And I'm trying to understand why, I understand the value of having separate counsel representing the IDA in potential litigation. But I'm not quite sure what the next step is here, since nothing is spelled out in terms of, a normal contract with a law firm would engage, talk about roles and responsibilities and costs and who's going to do work and what the scope of the work might be and all that kind of stuff. None of which is defined here. So I guess I need clarification as to what the purpose of this engagement agreement is at the current moment, especially if, as Kate suggested, nothing is going on right now.
Well, that's not nothing. I mean, there has been some work initially. Now there's a stay. So I was saying going forward in the immediate future, there won't be too much work, but I don't have it in front of me, but I think in one of the first paragraphs, it refers to the action, and the action is usually the scope of the work because we really don't know what it's going to entail.
Yeah, you've listed the caption and the index number. But we need someone to represent us.
No, I understand that.
And so Kate's presented, or Kate has represented us in, sent a letter to the port on our behalf, attended a meeting related to the procedural posture of it with the port's council. This seems totally normal to me, just with the scope of litigation. We don't know exactly how many hours are going to be involved because we don't know what's going to happen next with respect to the prior litigation, which is my understanding. So we get her to keep us up to date about what's going on, participate in whatever happens next, and then hopefully get this behind us once.
Right. Okay. But why is that outside the scope of council responsibilities now?
As general counsel?
I think, David, if we take a step back, this board engaged Whiteman to represent us in the port transaction. Whiteman, for some reason, decided that they wanted to also represent the port,
Yeah.
which created a conflict of interest after we asked them not to. Okay, now we need counsel with respect to litigation. So we have, when Kate came forward, we have two choices really. We can go hire another lawyer, or we can take Kate on, who's up to speed. We hire another attorney, we have to bring that attorney up to speed with respect to the whole transaction. So I think that, I think personally that going to Kate to have separate representation on this was a prudent decision on the agency's part. That's
The reason it's not in the scope of the other retainer is because, number one, the other retainer is really with regard to general counsel services for, board meetings, for, facilitating applications, reviewing, any contracts that the organization, engages in. And there's a very set limit on the compensation for that as well, as you know. So it's this, anytime a lawyer does something outside of an initial retainer, that retainer either needs to be expanded or there needs to be a separate matter retainer, as, we're doing here.
Okay. Fine. I mean, I just have to think about this a little bit. I'm not opposed to it. I just have not really thought about it until yesterday. Just need to make sure in my mind that we're honoring our fiduciary duty here to safeguard the assets and having a separate counsel does that. Yeah.
We ought to do this, and under the indemnification, it doesn't cost us additional cash to do so, right?
Okay.
Because we have an indemnification agreement with the port, so the port's going to pay these bills.
Hopefully. Right.
We discussed that already. So yeah, we ought to do this.
Yeah, I understand what you're saying.
Yeah.
I understand what you're saying. Okay.
Call the question?
What I would like to be able to do this morning is ask the board to authorize me to sign this agreement with the Hedgeman Law Firm with the language that Dick asked for, and Kate, you can read it, or, however you want to handle that ministerially. And the reason is that while there is a stay on this particular piece of litigation, we won't meet again until the end of May, and it could come back, leaving an unresolved issue. You know, have we authorized her to act on our behalf for this? How long do we want her taking action without a retainer and without clear express permission to implement the retainer agreement and seek reimbursement from the court? So I'm hopeful that we can have enough discussion this morning so that members feel comfortable taking a vote.
Okay, just one final question, clarification. We signed an agreement, retainer agreement, and then something happens, you know, with the, we need case representation. Do we need then a second document which defines scope of work and billable hours and all that kind of stuff?
This is it.
Which is open-ended.
Confined to a particular case,
Right.
which is referenced by an index number,
Right.
which we expect will be done with as it moves through the system. But yes, it's related to this particular piece of litigation, and it's totally usual to define a scope of services that way, from my perspective. When I litigate cases, this is exactly the way that I would write a scope of services.
It's difficult when you are not the person bringing the lawsuit, because when you bring it, you have a really good idea of, baseline things that have to be done. And you can say, I'm going to draft a complaint, I'm going to, and really sort of nail that down. But when you're defending, it's pretty much you're reacting. I mean, I can tell you right now that even with the stay in place, some of the lawyers aren't even paying attention to it. They're filing motions to dismiss, they're filing answers, they're filing cross claims. So all of that has to be reviewed. But I couldn't tell you, who's going to do what, because we didn't sue it, we're defending. So, I think right now we're in a waiting pattern with minimal, responses coming in to see what the decision is in the case. Then, they really have to file their administrative record, and that's 15,000 pages from what I'm told. So, it really, if we get to that point, I'm making a motion to dismiss on statute of limitations anyway. But, it's hard to know, because it's just whatever happens as a result of being sued. Plus, there's 30 parties in this action. So at any given time, I couldn't tell you if all 30 are going to respond, or, it's tough to do that.
Including federal agencies that have their, like, everybody's lawyered up here. We need her just to tell us what she's telling us now, and keep apprised of all this, so that we don't have to do it. Not to minimize it, but it's, I feel incredibly strongly that we should do this. I think it's imprudent not to.
I agree with that.
I would not.
That's the way of protecting ourselves.
Yeah, absolutely. Yeah. No, the fact that we can get her under the end, that she's willing to do it is great. That we have an indemnification clause that will cover the cost is incredible. Notwithstanding our conversation, I move that we empower our chair to execute this agreement and move forward.
I second.
I'll take a vote. We have a motion and a second. All in favor of authorizing me as chair to execute the agreement with the Hedgeman Law Firm?
Aye.
Aye.
Are any abstaining or opposing? Thank you. The motion passes. All five members present in favor. Thank you, and thank you for the discussion. I really appreciate, Ted, you're bringing in your expertise on this as well. So, Kate, does this need to be notarized?
Nope, it's just a basic retainer agreement. And I do need to send you a revised, with just the one sentence that, I will build the port first and make best effort to collect from them. And if they do not pay, I'll let you know. So I'll put that in there first.
Okay.
Okay. Yep.
Well, you know where to find me. I'm no longer the gold house with the broken siding. I'm the red house.
With the good side.
With the,
Not broken,
it, it looks like a stop sign right now. I'm hopeful that no other cars are going to miss seeing that we're there. So moving along, thank you all for that, and especially for taking your time to understand this. Next item under new business, Al, the presentation of the financial statements. Then we'll have Kate give us an update on where we are with Bella's board. And I do want to retain some time for the last item under new business, which is to start a discussion, no decisions, to begin the application review and update process. So, Al.
Okay, you have the financial statement through March 31st, 2023. The statement of net assets or the balance sheet, our cash account and the M&T checking account is $575,185.26. Our CD balance is $756,140.97. Total cash of $1,331,326.23. Other current assets, a fee receivable of $78,561.10. And I'd note that's already been collected and deposited into the account in early April. And prepaid expenses of $25,1252, giving us total other current assets of $81,073.62, and total current assets and total assets of $1,412,399.85. Our liabilities, our accrued expenses of $15,132.16, and our net assets $1,397,267.69, giving us total liabilities and equity of $1,412,399.85. If we go to the statement of revenue and expenses, you can see our fee income year to date is $175,125.33. At the end of April, we will get the first quarter PSEG reimbursement, so that figure will increase a little bit when we do April. Our expenses, contractual expenses are $33,561.62, giving us ordinary income year to date of $141,563.71. When you add in the interest income of $5,335.71, our net for the year is $146,899.42. When we compare the budget to the actual, our fee income, actually, the way I'm reporting it this year, are actually a little bit under on our regular fee income, only because we budget one project to close during the year, and that hasn't happened yet. It could happen. We may have extra income coming in from the Vista project if it closes. And our PSEG is running $18,166.98 over budget. Contractual expenses are $64,63.38 under budget. And of course, we're under budget on the business economic development line simply because there hasn't been any proposal put forward for the use of those funds. So our net income is about $50,773.50 above what the year-to-date budget is. Compared that to our annual budget, which we actually budgeted for a small deficit. So we're running ahead of what we expected, and I don't see that changing. Are there any questions on the financial report?
We're all shaking our heads. I do want to take a brief moment and note that our interest income is substantially ahead of what we budgeted. And we budget conservatively for a reason, but I especially want to thank Dick and Al for implementing our investment policy in a way that is generating more interest income than we anticipated or that we've had in prior years. It's not all because interest rates have increased, it's because they took a look at the policy and developed plans to implement it to our benefit. All right, back to you, Kate.
Okay, Bellis Board. Right now, I'm working with Bellis Board to get a lot of our documents in place within the system. And we've set up individual profiles for all of you within the system. So probably, I would say, maybe not by the end of next week, but early the following week, you will receive an email from me, a welcome email, which will give you your login and you know your password for you to reset your password, and you'll be able to log in and you know, see any and all of our documents that are available, and also a calendar. And they are willing to do a little bit of training, so we'll talk about that and whether you think that's something you want to do at a meeting, or you know, we can do separately too. That's fine. It's relatively easy. There's not a lot to the training to use the interface with the board, but we can certainly do that if need be. So that's where we are.
Any questions? All right, thank you, Kate. The last item under new business is we understand that we intend to revise our application for benefits. And because this is central to what we do, what I want us to do is spend some time today and at future meetings as a whole to discuss what we want to know about projects, what we want to see in an application, so that every member is heard and understands, and take, you know, no decisions until we're ready. And therefore, this morning I added it to our agenda with the 3 basic questions. You know, what should we know about the project itself? What should we learn about its effects on Bethlehem and the region? And how do we confirm that the financial assistance is necessary? And that's the if not for test that's being examined very closely. But I really want to start at the top. What is it that you want to know about the project? And that could be qualitative or quantitative. So I'm hoping that someone will open with, I think this is important.
I would like to say, change of what should we know about the proposed project and principles.
Okay.
I think we should know who the developers are,
Mhm.
who the businesses, and we do that. But I think that's important as much as the project, from my perspective.
For those of us who are new and haven't reviewed an application yet, could you give a couple sentences about how that review process has happened? I mean, that makes a lot of sense, but just don't want to be duplicative if we already are doing something, or at least get a sense for how we've done this before.
I think right now we have, and again, I haven't completed my research here. We have a rather lengthy application document.
Correct.
You know, and most of which is left blank and provides very little information.
Okay.
To us. And I think my sense is that for the most part, we've relied on either folks like John who come in and explain, we've met with these guys and here's what they're planning to do, or we invite them in to a pre-approval meeting or board meeting where they discuss the project and what it is they're trying to accomplish. So I don't think correct me if I'm wrong, but I don't know that we rely on the application document itself to get a feel for what we're voting. We rely really, I think, more on this kind of discussion. And I think it's probably important that to, one, try and streamline that document consistent with state law. And 2, to really get a flavor for the impact of the project on the town, Victoria State, who's involved, whether it's, and I think, and to me, equally important is to have a process to evaluate the document. And I think as we mentioned in other meetings, if we ever were to reject the project, we need to be able to prevent that rejection. And, I think it's important to understand whether the project is on solid, independent, solid financial grounds to proceed. The project is dependent on town support going forward. To me, that raises a little bit of a red flag that the viability of the project is not as strong as we want. But they should be wanting to come here for their own reasons, and we then provide the assistance that's necessary for us to provide the assistance to, for them to come. And so I think the whole discussion here is how do we, again, streamline a process so that we're comfortable with, the project goals, the people behind it, running inbound, the impact on the town, the type of project it is. We don't need banks and drugstores and stuff like that. So I think that was sort of the genesis of trying to, at least in my mind, to revise the whole application process. And I think there are some legal requirements under general municipal law that we're going to have to follow that make it a little bit more complicated. We can't streamline it as much as we'd like. But I think that's for discussion. But that's, to me, the purpose here is to make the document, I think, more relevant for our analysis than it probably is now.
So, for example, and I read applications to other IDAs on a regular basis, and streamlining is absolutely possible, and I'm really glad that you mentioned that. Some IDAs will ask for a narrative describing the project and why it's important, and setting forth, less measurable benefits to the town. For example, they're reviving an underutilized building, or you can't get this it isn't available in town. So what I'd like to do is go a little bit deeper into what do you want to know about the project itself, and we'll come back around it to how do we feel comfortable that the developer partner is in fact reliable and stable. That's a more complicated question. So, a project says, I want IDA assistance, and what's the first question that we want to ask?
One of the questions I would just put on your radar for discussion that falls into what I consider to be the legal bucket and the public perception bucket is to tell us how, give us a narrative of the but for. So when you review an application for IDA benefits, the biggest question, legal question in my mind is, but for these benefits, would you be able to do the project? And so as part of that narrative, I, would like to see more than just one sentence, about why you can't do the project without the IDA benefits, and then to back that up with whether it's financials or whatever it is, lender requirements, whatever that looks like. Because that's something I see across IDAs, is that usually isn't there for the board to review. And it's really important because you may have seen the news too about a particular IDA getting jammed up because on the application, somebody did not check the box that, they couldn't do the project without the funding. So, as part of any narrative, I think that is definitely something we would want to see.
And just to add one piece, I agree. I think that would be really important. I think in addition, in the but-for case, I think in addition to the financial aspect of it, and this can change, for project to project, but I think also a project identifying or making the case that there are other options in other locations that they can pursue as well, right? So it's not, I think that's a part of this piece as well, right? That there are, that this helps make the case for why the project should be about.
We're competing.
Correct. Yeah.
It's a competition sometimes.
Right.
We are competing, and those of you who are on the board in December 2020, when we reviewed and approved benefits to the Cannon Development Project, they asked for an enhanced pilot abatement. And for the first time, we actually did a quantitative, if not foretest, on pro forma financials, looking for the project, not for the firm, for the project. Does this genuinely need, what are their cash flows look like? What does the revenue look like? What is the effect of the pilot in improving their bottom line? Can they actually make it a viable project without a pilot, or is it justified? And so I conducted that analysis for everyone to review, and we did determine that the enhanced pilot was merited based on the likely project performance. It passed the if not for test. What I find with our applications is we ask for very little information about the project. Someone wants to build a building, someone wants to build a warehouse on this lot, and they think there's going to be 2 jobs and it'll cost $15 million. And that's what we get. Does that feel like enough? What are we missing when that's the information we get?
I think that, so Canon checked the boxes. If we go A, B, and C, Canon really could be a poster child for a good project and good application. Fit everything nice and easy. Other projects, we have, I think, drilling down B and C, I think that's what the committee really has to focus on.
In implementing the town's comprehensive plan, I think we need to be very clear. And when we hear about projects, especially, Kate is often the front line, Kate and John are the front line. Applicants want to build something in the town of Bethlehem, and everything that we do goes through the town's processes. Sometimes there is a sentiment that IDA benefits are as of right, that because they're doing a project in town, they automatically qualify for a pilot. And that is absolutely not the case. We evaluate the financial strength of the builder when we can. We can be better at that. We always look for the if not for checkbox. We started looking at a quantitative analysis supporting that. But we still don't necessarily know, why they want to build the project here, how big is it? We don't even necessarily get salary information. So these are the kinds of things that we're also reviewing, because we're trying to decide, is this really an appropriate project for us to support? And if the answer is yes, then we say, okay, and does it merit our support? Does it need our support? So it's a 2-part question.
We're going to be looking at spec warehouse. That one is dirty.
That might, something like that come in.
It's very hard to figure out. I think.
Well,
we want them. Well, so there's a variety of processes, and I'm taking a quick look at the Canon application just because I hadn't seen it before. And I was also looking at our uniform tax exemption policy, and we've got 17 criteria that are stated upon which we review applications, right? There's so looking at what's out there, and a number of our peer IDAs have some policies or rubrics that they use for scoring. The City of Albany IDA went through a process recently. They basically have minimum criteria. You have to tick all those, and then there's supplemental ones.
And I'm working on the criteria too, a lot of which is based off of Albany. So that's more to come from that. Yeah.
There's also, Ulster County has one that I think is worth looking at. Clinton County has one as well. So I think it's an important conversation, and I've spent some time looking at these and working with another IDA, and Victoria has heard me talk about this. But I think it's an important discussion that we're starting. And I think, I don't know what direction you want to go today. We could refer, I don't know if the governance committee has talked about something like this. We could either continue within the full session or have a committee follow up with potential ideas.
I don't want to send this to a committee right now. That
Okay.
could be useful in the implementation stage. Like all small IDAs, it is a challenge for our committees to meet.
Sure, yeah, sure.
So I do want that input. But, Ted, you bring up something really important. We're coming up on 9 o'clock, so since we don't have to make decisions, let's follow on what you're suggesting. We do have those criteria, and our application is posted on the website, a blank application. So the first thing that
Right.
each of us should perhaps do is take 20 minutes, read those criteria, understand them, and determine whether or not the information requested actually helps us understand whether the project meets that particular criteria. My guess is that we created the criteria without doing that crosswalk to begin with. And that could be a starting place for us to say, hey, we're supposed to evaluate this. We don't know anything about it. In our copious free time, but it is important, especially if we do move forward and have a specific rubric, we need to hang our hat on something.
I thought one of the items for the upcoming governance committee meeting, 2 weeks or was 3 weeks, was to begin to discuss the application process.
Mhm.
So, and I think it's already been referred to the committee in that sense. But obviously it's going to take a year, I think, to flesh it all out.
It is my hope that we could have it done more quickly, and I'm not, disagreeing. There is a potential that we get applications coming in. I want the application, to the extent possible, to be settled so that we don't have an applicant submitting under the old information and us going back 3 or 4 times saying we've determined that we need more. We really do want to avoid that. So that's certainly something to keep an eye on.
So we've got to do our homework before the 19th.
Yes.
Yes. Which has been our charge.
Yeah.
Yep.
Thank you,
And-
May.
That's our
Yeah.
next governance.
Yeah. And every member can come to governance. You do have other business on the agenda for governance. That's an important one.
But
I'm gonna have some things that I'll get to the committee well in advance, just to sort of use it as talking, to start a discussion, including the rubrics. So we can have that for May 19th discussion.
Just wanted, to add to, clarify a point that, or adding to a point that Victoria made earlier. I think, the idea that, maybe there's a perception that, amongst developers or projects that IDA benefits are as of right. That certainly doesn't come from our office. We're clear, when we first meet with a project that, we can discuss potential IDA benefits and look at this, but we're very clear on kind of that process and setting the expectation that it's not by right. So.
Mm-hmm. Thank you.
Yeah.
And that is absolutely true.
I think the corollary to that is, we have hundreds and hundreds, thousands of businesses in the town of Bethlehem. And we have 14 projects, 12 projects.
Mm-hmm.
So most people who do business in town of Bethlehem never come in contact with the IDA. So I think we have to make sure that if there is a business that does receive benefit, what's the impact on existing businesses? And how fair are we to them? And are we creating some kind of competitive advantage for a new business? When we have other businesses that have chosen, to sort of go on their own. So I think I don't know how you measure that, but that's, I think, something else we have to do.
Any additional thoughts? Well, I will entertain a motion to adjourn.
So moved.
Yeah, oh, wow, you really jumped on that one. Dick, you got there first. Who's the second? Victor seconds. All in favor of adjourning? Aye. Any abstain or opposed to adjourning?
I just went from the also.
So at 9:02 on April 26th, the IDA adjourns its regular meeting. We meet again on, it's bottom of the agenda. We have the governance committee on the 19th and a regular meeting scheduled for the 24th. Thank you.
Tuesday.